Good evening, all. Hope I am audible and that you are able to see the presentation. Then we can move on with the presentation. Friends, in our domestic corporate law webinar series, we have been discussing about this fund management concept and principles. To begin with, we started about the fund management in India, and then we moved on with the various legal agreements which, as AIF, we may have to execute. And we also discussed about the basic nuances, legal nuances in AIF and the various categories, category 1, 2, and 3. In the fourth series of the same subject, today we are going to discuss yet another interesting topic, which is AIF in IFSC, International Financial Service Center. Why do we have these financial centers, friends? Financial centers, as we all are aware, is a cluster of various market entities. It could be your banking, it could be your insurance or financial sectors. For the vision to go ahead with their vision as an agglomeration of various institutions together and to provide support services together. So this is why we have this financial centers in place. Then what is the role of this IFSC we are going to see? To promote this IFSC for ease of doing business and to create an edge over the various global hubs like the global financial centers which we have in Dubai, Singapore, to create an edge over other global financial centers. How India has moved ahead in this particular path of promoting this IFSC with various incentives, be it your regulator incentive or your tax incentives, we are going to discuss today. And we will also see how these registrations occur, the specific form. Thanks to my team, Aishwarya and Subhash, for this detailed exercise and the presentation. These are some of the legends which we have used in today's presentation. Predominantly, you all are aware about IFSC, International Financial Service Center, and the authority which supervises this IFSC, which is your IFSCA. And of course, SEZ is again interrelated. We will see how Special Economic Zone and GIFT City, Gujarat International Financial Tech City. So these are the four fundamental structures basis which the entire AIF and IFSC, this particular structure works, and all others are just for your ready reference. We're going to see a brief history of IFSC, the legal requirements, and how this AIF and IFSC is incorporated. What are the processes and the merits and demerits of AIF and IFSC of being this alternate investment fund in this financial center, and the various benefits attached to it, the tax exemptions and the registration cost, the various categories for which the application and registration fee as prescribed in the FAQ issued by SEBI, and some interesting statistics before we conclude. A brief history of IFSC. The two operative sections under SEZ Act are Section 18 and 55. These sections provide power to the central government to set up and operate IFSC, while Section 18(1) talks about the central government having the wide power for setting up and operating this IFSC. It also provides for prescribing the provisions for setting up and operating this IFSC, and thus Section 55 of SEZ Act lays down the rules, which inter alia also talks about the establishment of this IFSC, the various rules and strings attached to the setting up and operation of IFSC. These two are the fundamental sections under your SEZ Act. Friends, please remember there could be only one IFSC which could be set up in a special economic zone. India's first IFSC came into limelight at GIFT City during April 2015. On 11th April 2015, we saw the first IFSC being set up in the GIFT City. IFSCA Act, which clearly draws the specific rules and the powers for this entity, being IFSC. The unit came into force on 20th December 2019. The bill was placed for approval on 25th November 2019 and it finally got the assent and it came into effect on 20th December 2019. IFSCA has been established on 27th April 2020, assuming wide powers and overriding powers over the other regulators. Friends, the main advantage of this particular IFSC, the IFSCA, is they act as the unified regulator. Since we already observed that the financial centers work as a cluster of all the financial services which are rendered, like the banking, insurance, or the other financial services as may be rendered. This acts as a single window mechanism. This authority thus has overriding power over the other regulators. We are going to see how they have this superseding effect by virtue of the specific provision in the subsequent slides. Currently, they are headquartered at GIFT City, Gandhinagar, Gujarat. Why do we have IFSC? This is a platform for undertaking various financial service transactions, either by the overseas financial institutions or the Indian financial institutions. It could be a bank or NBFC which has its overseas branch or subsidiary. The denomination, where again is the biggest advantage, denominated in foreign currency in India, which at present is being carried on outside India. So this is this offshore model which is established. Instead of going outside India, you are having this separate IFSC constituted for both the financial institutions which are global and the domestic financial institutions which have their overseas branches or subsidiaries. How was this model working before this IFSCA, the authority for IFSC, was constituted? This was regulated by none other than the respective regulators. For banking, the RBI; for capital markets, SEBI; for the pension funds, PFRDA; and the insurance, IRDA, Insurance Regulatory Development Authority. Now comes the overriding effect. Section 30 provides wider power to this IFSCA. What do they say? This IFSCA shall have effect notwithstanding anything inconsistent contained in any other law, which means they acquire substantial power and assume this particular higher authority over this particular other regulator, since this is going to become one unified regulator by virtue of the provisions granted under Section 30 of IFSCA Act. This is a broad gamut of the timeline chart, how this has evolved and how the current structure is, with some of the key milestones which have occurred in IFSC. March 2015, we had the Principal Operating Guideline. 27th March, SEBI issued these regulations for AIFs in IFSC. However, these regulations were very complicated and it was not providing any added incentive, and thus this Policy Advisory Committee, the Alternative Investment Policy Advisory Committee, we call it shortly IPAC, they presented their report along with other stakeholders. Of course, they would have taken all other regulators in confidence, RBI, SEBI, who are the real stakeholders. Along with their recommendation, they submitted a proposal during Jan 2018, and thus the revised Privileged Operating Guideline came into effect on 26 November 2018. Then we move on. May 2019, the trust was allowed to set up units in IFSC. Originally, you had the LLPs, the body corporates, the companies, and then the trusts were also granted this privilege to set up units. In July 19, income from offshore investments by NRIs through category 1 or category 2, not taxable. This benefit was provided by the CBDT notification on 26 July 2019. Thus, providing various incentives to all these income by the NRIs not having the taxability, they're not coming within the taxability ambit. And July 2019 again saw another exemption granted under your 139 from filing income tax return by non-resident investors in category 1 or 2 AIF subject to conditions. This was again an additional merit provided to NRIs. Again, this CBDT notification provided this particular exemption to NRI investors subject to various conditions. What are they? 1. These NRIs should have obtained income only from these AIFs, that is category 1 or 2, not otherwise. 2. The respective TDS, whatever has to be deducted out of this income, which is arrived from these AIF, they should have deducted it properly. And the third condition was these NRIs, they have to give their complete name, address, where they are residing outside India, and the tax identification number, whatever they have in their respective jurisdictions, to the respective AIFs. And in turn, onward, submission should be made by these AIFs to the tax authorities by virtue of a quarterly statement being submitted in the prescribed form. So these were the strings attached to this particular exemption granted. Then we move on. Additional tax reforms were announced in the light of the Finance Act proposed in the budget 2019. In August 2019, permissible investments by AIFs in IFSC were further expanded and aligned with domestic AIFs. We are going to see in the next slide as to what are the permissible investments and what are the additional investments which were provided for IFSC in line with the domestic AIFs. Friends, please remember, we already had this concept called domestic AIFs. Now, over and above that, you have the additional ambit of AIFs in IFSC. Today, we are going to discuss on AIF and IFSC in particular. August 2020, there was yet another CBDT notification which was issued providing this greatest benefit which many of the overseas investors were looking for. They considered this to be a stumbling block from investing in AIFs and IFSC. What is that? The mandate of having one permanent account number in India. When they are NRIs, why do they need PAN was the contention. And several representations were received and they were considered on merits, thankfully. And this exemption has seen the light of this particular greatest exemption provided to all these NRI investors from procuring PAN in category 1 or 2 subject to conditions. Again, those conditions as mentioned before, like they should not have any other income other than this category 1 or 2 and prescribed details to be provided to the AIF and AIF in turn submitting the quarterly statement to the authorities concerned. This is the timeline chart, just a broad overview. Now we are going to see the legal requirements, friends. As mentioned earlier, permissible investment. Already we had 3 buckets of permissible investment by the AIFs which are set up in IFSC. What are they? Securities which are listed in this unit, IFSC. Securities which are issued by companies incorporated outside India, or securities issued by companies in India or belonging to foreign jurisdiction. These were already prevailing. Additionally, securities in which a domestic AIF is permitted to invest was additionally provided as a relaxation as discussed in our timeline chart. What are the securities in which domestic AIF is permitted to invest? Like your real estate investment trust, REITs, your InvITs, infrastructure investment trust, SPVs, your special purpose vehicle, or any complex or diverse strategies in which AIFs do invest, or derivatives. So LLPs. So all these investments which were hitherto applicable for AIFs, for harmonization, to bring AIFs in IFSC also on par with the other AIFs, other category 1, 2 three AIFs in general, they have brought this particular additional permissible investment in force. Who are permitted to invest in this AIF in IFSC? Person resident outside India, non-resident Indian, institutional investor, resident in India who is eligible under FEMA to invest in such offshore funds, and person resident in India having minimum net worth of USD 1 million during the preceding financial year, who is entitled under FEMA to invest in such offshore funds to the extent as allowed in your liberalized remittance scheme. So, whatever is allowed under your LRS, you are thus granted provision for making such investment up to that cap of LRS and not otherwise. The prevailing SEBI operating guideline, which we saw after this advice of the Policy Advisory Committee report, the investment route provides for three channels. One, under foreign direct investment. Two, your foreign portfolio investment or your foreign venture capital investment. Friends, initially, this was restricted only to FPIs. Thankfully, again, for relaxation of various norms for AIFs investment in IFSC, additional provision is granted for investment route available to FDIs and FVCIs as well, subject to the norms, subject to the limits as prescribed under FEMA. And next comes your options available to a sponsor manager. In our previous webinars, we have already seen who is a sponsor and who is a manager. And if you are going to be a new sponsor or manager who is going to set up this AIF in IFSC, then you have to do it only in two options which are allowed. One is either you incorporate a company or incorporate a LLP. However, if you are already an existing sponsor or manager and you already have one existing AIF in IFSC, then you have additional third option, which is setting up a branch in IFSC. Some of the legal requirements under IFSC Act. Again, this is going to be a broad overview, not in detail. Every transaction of financial services in this unit shall be in foreign currency as specified in the regulation. Of course, in consultation with central government only, since central government assumes wider power. Section 20 of this IFSC Act prescribes this. Section 4 and 5 also provide that IFSCA, with the approval of central government, shall establish its office. Thus, the authority shall establish its office in consultation with central government and appoint such members for carrying out necessary function. The authority, of course, need to be presided over by a chairperson with two members, the ex officio members of your RBI, IRDA, PFRDA, SEBI. Why? Because you're going to have those wider powers and all these conglomeration of various financial services you're going to operate in your unit. Thus, it is imperative for you to take the views of all these regulators. Two members, each from the Ministry of Finance and two other members from the selection committee, of course, in consultation with central government. This is how the composition works. Section 13 again is yet another important section which gives superior power to this IFSCA for regulating either the financial products or services or institutions in this particular unit over other authorities, which means they assume wider power as compared to other regulators when it comes to these financial products or services or institutions as set up in this particular unit. Let's move on to the process of incorporation. First, you have to identify an office space in this unit. I have identified one office in the gift city. What will I do then? I will express my interest to the DC, the Development Commissioner in SEZ. Upon receipt of my interest for seeking an office space, they will provide PLOA, which is called Provisional Letter of Allotment. Then, upon receipt of the confirmation that there is this seat available for me in the IFSC unit, I will move on to set up my constitutional company or LLP or trust, as the case may be. We all are aware of the procedural requirement for formation of all these entities. upon incorporation or formation of these entities, we will move ahead to make an application submitted to SEZ, Development Commissioner, the authority for granting approval, IFSCA being the authority for setting up the unit in IFSC, and SEBI for their approval. Why SEBI again? You have to go to SEBI for your AIF constitution, you have to go to IFSCA for your IFSC constitution, and you have to go to SEZ for having this particular unit set up in this IFSC. Application, the prescribed form is F for SEZ approval and form A for IFSCA. Some of the enclosures to be submitted to the relevant forms, we have just given it for your reference. This form should be filed with the Development Commissioner, Kandla, SEZ, along with your incorporation form certificates. If it's going to be a trust, the trust deed, and the proof of having registered the trust, the demand draft, project report, board resolution for setting up and operating this IFSC unit, all the list of items, the capital indigenous goods, the address proof and ID proof, the KYC documents, ITR submission, PAN code of this entity. So you may have to obtain your IE code, your PAN much before submitting this application, PLOA, and an affidavit. On receipt of approval from SEZ and IFSCA, you will submit this specific form A with SEBI. On receipt of SEBI's approval, final letter of allotment will be issued for allocating this particular space in IFSC unit. Lease deed shall be executed with the developer for office space. Now that the entire structure you have obtained all the necessary approvals from various regulators, you are assured to have one office space in that particular unit, and thus the lease agreement shall be executed between this AIF and IFSC and the developer for this office space. There are several benefits provided to IFSC, friends. IAF is treated as person resident outside India. Thus, it enjoys the benefit as a non-resident under FEMA provision. Income accruing or received by NRI from offshore investment, we already saw this provision in our timeline chart, through category 1 and 2 in IFSC are not regulated. So they have this pass-through benefit and they are not taxed in the hands of this particular NRI when the income is accrued or received by NRI from these categories of AIFs. And various tax benefits we are going to see in the next slide as to what are the specific tax benefits available under your Income Tax Act read with rules. And of course, regulatory incentives are provided and lower operating costs due to the subsidies granted by Gujarat government. In order to promote this particular business and in order to have this global standard, global benchmark being achieved, the Gujarat government has come out with various subsidies for setting up this AIF and IFSC. So they are also provided for these units. Proximity to onshore market. Being an offshore fund, you have the access to the onshore market since your BOSES or the international or Indian stock exchanges have that particular unit set up in IFSC, and thus you have easy access to onshore market. No doubt, access to various multiple markets from IFSC is thus allowed. Of course, it has few demerits as well. In the recent RBI circular which was issued, it was provided that any sponsor contribution from this sponsor Indian party, which is setting up this AIF and IFSC, will be treated as overseas direct investment. And thus the Indian party should have earned the net profit during the preceding 3 financial years from this financial service activity to make it come under automatic route. Otherwise, approval has to be taken from RBI. Why? Because this particular contribution received from a sponsor Indian party will be construed as overseas direct investment. Hence, your regulation 7 of your TRIFS regulation, the transfer of this foreign security or issue of foreign security regulation 7 clearly mandates that when there is such transaction happening, if you are not going to fall within the conditions, then you have to seek approval. You have to come under the approval route, where one of the condition attached is this Indian party should have earned net profit during the three preceding financial years. Of course, this regulation 7 is more for the financial services entities, which talks about this direct investment by all these Indian parties in a JV or WS. So that master direction of O6 direct investment will squarely apply to these AIFs and IFSC is the recent RBI circular under FEMA. So you will not be able to escape from this provision. And though the procedures have been well streamlined, there are few provisions which make it necessary for us to approach the consultants to take their help and assistance to draft all these forms and submit the papers in order to expedite the registration process. And initial compliance requirements are high since you have to go to multi-regulators for approval. Already we have SEZ, IFSCA and SEBI granting approval and specific form attached to each specific regulator. Some of the tax exemptions and cost involved, again, an extract from the Income Tax Act, and the cost involved is again an extract from the FAQ issued by SEBI for these AIFs in IFSC. Section 80 LA provides Category 1 and 2 AIFs to have tax pass-through for Indian income tax purpose. However, the business income is taxable in the hands of this fund, for which 100% tax holiday could be claimed for a period of 10 consecutive years out of the block of first 15 years, according to Section 80 LA of your Income Tax Act. 10(4)D already we have discussed about the income accruing or arising by or received by this NRI will be an exempted income. Investors can claim losses of AIF on pass-through provided the units are held at least for a period. The retention period should be 12 months or more. However, business loss could be carried forward only at the fund level, which is Section 115 UB, and Rule 114 AAB says that exemption to NRIs from filing the return of income is provided they earn income only from the investment which is made in either Cat 1 or Cat 2 AFC and other streams which we already discussed. That the deduction on this income, the TDS, whatever is applicable in this income should have been filed, and they should have disclosed their categories of investors, all those TIN numbers, whatever they have submitted to their respective jurisdictions to the Indian AIF and IFSC as well. And in turn, this unit should have submitted their quarterly statements. And MAT has been reduced from 18.5% to 9% as per Section 115 JB of the Income Tax Act. The cost application fee is USD 1,500. Registration fee for each category is 7,500, 15,000 and 22,500 for 1, 2 and 3 respectively. And for angel funds, it is 3,000. And if you are going to make a re-registration, then the fee is 1,500. So this is the cost attached towards the registration. We will conclude this presentation with an interesting statistics. Recently, this Global Financial Centers Index has this London report, which was released as latest as 17th March 2021, gives lot of inviting inputs to all of us, because this GIFT IFSC, the Gujarat IFSC, is ranked first in the list of this Global Financial Centers Index report, which has 15 centers which are likely to be becoming more significant in the future years. And GIFT IFSC is ranking 10th in the finance sector sub-index. Of course, New York is ranking in the top first in various centers, be it your finance sector or your banking, insurance. In across all the centers, New York, of course, in one of the sub-index, Shanghai is in the leading side. Further, reputational advantage. What is reputational advantage? Again, this particular report draws reference to the difference between the average assessment given to this particular center, financial center, and the overall rating in the index. There again, India, this particular GIFT IFSC is ranking first. Thus, India is rated more than the intrinsic worth, which is perceived by many of the professionals across the globe. And FDI inflows, also Gujarat is leading. If you see, of the top 10 states which are receiving FDI inflows, Gujarat is leading. Until the period ending June, Gujarat was either ranking in fourth or fifth place, but increase in FDI flows during the quarter ended September again led to Gujarat leading the first rank in the FDI inflows. Thus, we could conclude that setting up of IFSC in the GIFT City is no doubt a welcome move. It provides lot of exemptions and privileges to NRIs with various tax benefits and the regulatory relaxations which are available, along with the subsidies provided by the Gujarat government. With the entry of IFSC, we have noticed that the FDI inflow in the country has also significantly increased by 19.8% during the period ended December 2020. Friends, with this, we are concluding today's session. I'll be glad to take your questions. Otherwise, we will continue the same fund management session in our next series of presentation as well.